Jan Logie.
Thank you, Mr. Speaker. I rise today to speak to the Privacy Information Sharing Bill. And this is the fourth piece of legislation with significant privacy aspects that I've spoken to over just the last year and a bit. And again, sadly, I find the need to express the Green Party's opposition, because we have an opposition that seems to the fundamental direction of this government in relation to our shared privacy rights. And I think it's also salient to remember that over just the same period of time, which just feels so fast to me, just over a year, the government has had to deal with multiple major privacy breaches within government departments. IRD, ACC, work and income, justice, immigration, and of course Nova Pay. Privacy is the issue of the day, and a lot of the annual roundups of the 2012, privacy was at the top of the list of the items of importance for this country. And so what is this government's response to what I think could fairly be said to be a crisis of systems, a systemic crisis in relation to the protection of people's information? Well, we've been given this piece of legislation which actually seeks to extend the sharing of information with no further assurance of protection of people's information. And that, to the Green Party, is an anathema, and it's a massive lost opportunity. We absolutely acknowledge the need to update our privacy laws and ensure a clear process for protecting people's information. It's a concern to us, and probably more than a concern, to hear that the current law is not being consistently or logically implemented, and that is something we do believe needs action. We certainly support anything to fix those problems, but sadly this piece of legislation does not give us the confidence that rights are at the centre of this government's approach, or even that this piece of legislation will solve or go anywhere near solving the problems that exist from the perspective of a citizen. And for us, they should be at the heart of any changes to privacy legislation. People require a sense of security if they're to feel comfortable within their society. And one important facet of security is the capacity to control information about oneself. Therefore, the principles of privacy as a means of controlling that information are vital contributors to an individual's sense of security. So it's a fundamentally important human right. In my first reading speech, I referred to a pregnant woman on the DPB who was escaping a violent relationship, who had recently just told her community organisation that she was working with that she was considering hiding her pregnancy because she was scared that if Housing New Zealand or Health found out about her pregnancy, they would tell Work and Income, and she would experience incentives to find work more quickly than she could actually cope with. I listened to the submissions that were made on this bill. I heard the support, qualified and unqualified, for this bill. But I listened to that information and their views from the perspective of this woman. Was what they were saying, would this bill help this woman have confidence in disclosing and getting the help she needed to be safe? And I didn't find that assurance. And for me, the experience of this woman and others like her need to be at the heart of our policy making. And a Labour colleague, Leanne Dalziel, also mentioned the lost opportunity that seems to have been missed from the not picking up a standalone child welfare statute that could have gone some way to actually consciously front on looking at those issues. And I think that's a shame, and I do hope that the government may consider in the future actually looking at a piece of legislation in that light, because I do believe as a society we need to confront those issues and its interaction with privacy legislation. A nuanced message of responsible information sharing, as we're hearing from the government, won't be heard by our most vulnerable people. The drive to hide information can dramatically increase people's isolation, and we have a duty to protect our most vulnerable. And they, for me, are at the heart of what we need to consider when we're looking at this legislation. This bill will increase the amount of information sharing that government agencies can undertake in order to accomplish this goal of better public services. For me, that's about front. You know, actually, what we need our privacy legislation to do is to enable our citizens to access services and get the help they need and to be safe. It's not about the delivery of government services. That's completely secondary to what should be the focus of this bill, which is our citizens. And while another stated goal is to ensure that privacy remains highly protected, increased information sharing between government departments actually means the individual enjoys less control over their personal information. That's what this bill does. And because of the centrality of public service to this bill, the individual's relationship with the state becomes pivotal. And as we've heard from that list of government departments that have actively breached people's privacies, you know, that relationship isn't in good shape at the moment. And we need to be focusing on how we can increase people's confidence rather than extend provisions that potentially undermine that confidence. Technology is often touted as a reason for privacy laws to be updated, and with good reason. Absolutely support that. We're in a changing world and our legislation needs to change with it. But this bill does not relate to technology, and it seeks a readjustment of the core privacy principles that impact on the rights of the individual vis-à-vis the state. One particularly concerning element is the empowering of the executive to create information sharing agreements by regulation. And this could result in agreements that are not in keeping with the principles of the Privacy Act, and by extension gives the public less reason to be confident in the integrity of that legislation. Scrutiny of the agreements is also a potential issue because copies will only be made available on the internet, which some people don't have access to, or in the head office of lead agencies, which imposes its own set of access issues for those not in the vicinity. Moreover, the decision not to carry over 96T has serious implications because it increases the likelihood that information will be passed to agencies not envisioned in the original agreement. Diluting the requirements for when private sector agencies can participate in the information sharing might contribute to a misplaced sense of certainty on the part of the agencies, but it does not contribute to a sense of certainty on the individual on how their information is to be disseminated and used responsibly. If you don't know who your information is going to be shared with, are you going to want to share it at all? The Law Commission's landmark report on privacy law in Aotearoa, New Zealand, made two key recommendations for empowering the Privacy Commissioner to protect against the sorts of breaches that are happening. And the first of these was that the Commissioner should be able to issue compliance notices, and the second was the power to require an audit of an agency's practice and systems for handling private information. And these would have brought the Privacy Commissioner's powers in line with the majority of comparable overseas bodies charged with the protection of privacy. And this would have really addressed a lot of our citizens' concerns. But tragically, these measures are not included in this legislation. And for us, that is a fundamental problem, which means we cannot support this bill. We want legislation that has the citizens' needs and human rights at the heart of it, and we regret that this does not.
Alfred Naro.
Speaker, thank you.